to go.
All of his case answers apply to the number one. We're not going for the number one. It's in the number two. The plaintiffs won't be able to get through the courts because they don't have enough court resources. It is specifically a court clogging argument, except of course the number two argument. That means that each judge would have to deal with 421 cases, and it would increase the caseload by over 6,000 cases, which means that the courts wouldn't be able to handle it. They wouldn't be able to provide civil remedies, which means that they wouldn't be able to solve it. There is no answer to this argument, which means it takes out all of their arguments, and the card also gives a specific analysis about how we are going into an impending crisis right now, which means that we need to, if anything, limit the court cases that are going into the court, not send more in, counterplan. His first argument is there's no solvency because of the McKinnon evidence. Well, one and the evidence says that the VAWA should be implemented. That means that our counterplan would be able to capture that because we would implement it, which is beyond other grounds. McKinnon evidence gives specific analysis why the Commerce Clause would be uniquely better. And two is that the Equal Protection Clause would be able to solve better because it would specifically address the gender violence and not just the economic prospect of it. And three is a cross-play or one and C Article evidence, which specifically talks about how it is an equal protection issue. This means that the counterplan would deal with the issues at hand and would be able to deal with gender violence. More specifically, that means that would be the focus instead of commerce. And next is on the permutation. One is this card talks about how a more narrow view. Its warrant is that we have to have a more narrow ruling on this, and that's bad because they want to have a wider viewing of this, which means that this takes out a solvency for the affirmative as well. And two is that it links to the net benefit just as much because it still uses the Commerce Clause, which means it still incorporates the mentality that we have to remain within the capitalist system. And next is extend our MR99 evidence from the 1 and C using the Commerce Clause as nothing but a strategic ploy to get the Supreme Court to approve VAWA. There is no net benefit. There is no benefit to its inclusion. And next is this strategy of combining Commerce Clause and rights claims creates a more distorted system, destroying all hope for future rights and change. That's Pope in 2002. Views the popular sense of contrast between the infinitely and distorting only being the baseline of the constitutional text because the baseline the popular will, the right, and the movements frame reflects the language of human rights, not commerce. The attorneys assigned to defend the Constitution and downplay these skewed altogether language and freedoms instead of the statute of the language of economics that could be used to justify the existence of commerce power. The ultimate between the Supreme Court decision and the United States versus more human rights do not sound into the language of commerce without interest. They henceforth the 13th and 14th Amendments, the old limitation of the Federalist View, the Commerce Clause of the Populist View, and the two rulings clash badly. The Commerce Clause of one half of the distortion remains uncorrected, and the result is more than oddly with the regime. The statute that merely misclassified all arguments, commerce power, outside the scope of congressional power altogether, the immediate prospects of revitalizing human rights provisions are bleak. The popular movements must now start from scratch. And their next argument is no negative fiat, but when there is an implied counter-resolution, when the affirmative should implement the resolution, the negative should not implement the resolution, which means that we get our fiat power from that. Two is this key to broader education and more arguments because we wouldn't be able to run any other critiques or counterplays that they can see in cross-sex. And three is these are key to negative ground because if we were stuck defending the status quo, we would have to win that nuclear war would or that disads would outweigh everything, which doesn't work with a critical app, which means we would lose every round. The next argument is that there's no solvency because of the binaries, but one, it just says that we need to overrule the Morrison decision. Two is that it would be perceived the same as a worldview, and still be perceived as us re-implementing VAWA and making a civil rights remedy. Three is that the equal protection clause applies best. Press apply the above analysis. And next is we must reconceptualize the 14th Amendment through Morrison in order to solve that. Safeguard in 2006. The best way to understand the result of Morrison, the product of bad law. Morrison is the continuing failure of the state action and highlights the continuing urgency of discarding the old Reconstruction cases and adopting a new state action rule. And current 14th Amendment law makes racism inevitable. That's Safeguard in 2006. The state action that applies the 14th Amendment is the rule is grounded in racism, contemporary reliance, the minor racism reality to eliminate the discriminatory practice of those in Morrison and prevents Congress from regulating private discriminatory contact. It shields the power of the security and systematic racism of racist policy until the court of state action problem. The struggle for racial equality in law will be a losing battle. And okay, racism leads to extermination. That's Copeland 88. There is an indubitable link between the dynamic of society and the racism, external projection, the violence, the thermonuclear deterrence always decayed the apocalypse of the first strike capability of friends, the important history of its healthy disposition of racism will play a pivotal role in the outcome of a nuclear crisis. The movement will have to be able to link it to the militarization and racial oppression. And their next argument is the no topical counterplays, but their first name for that is education. However, we get more in-depth education over their case by being able to talk about specific points of that, by being able to we get some more specific topic education. Their next argument is ground. However, we get more ground. They get more ground for terms because they have to have a specific reason for defending the Commerce Clause. That means that they should have terms against the Equal Protection Clause, which means that there's more case-specific research and they can be better prepared. Their next argument is fairness. However, literature checks all of the different counterplays that could be there. because we have to have a good piece of evidence, or we're not going to win any solvency on this. Next, the counter-interpretation of plan focuses best because it leads to in-depth education over the plan and better clash and fairness. That solves all of their offense. Their next argument is that there's no solvency because of the 14th Amendment grounds, this is the federalism argument. One, there is no impact of federalism. Round 2 is this talks about VAWA in general. It doesn't make any specific claims about either of the clauses. And 3 is it says it talks about civil rights remedies, which is in both their plain text and ours, which means it applies to both cases equally. And their next argument is there's no solvency because it only deals with slavery issues, but 1, it says we have to provide equal protection. Just because it was used for slavery doesn't mean it can only be used for slavery. And 2, it was used in the original VAWA decision, which means it applies there as well. The next argument is that this will lead to more civil rights legislation. But when this says that this also talks about a court's narrow reading, and 2, it says that it doesn't mention the equal protection clause. It just talks about how the commerce clause would lead to this, and it's not exclusive to the other one. Next is that their PIC's argument that it's simply aggressive. 1, there's no impact to this argument. 2 is that literature reject too many PICs, and 3 is that PICs force them to defend all lengths of their plan, which leads to better education about their plan.